morning. Could you please restate your name for the record?
Officer Jonathan Reeves,
And are you currently employed, and if so, in what capacity?
by the city of Detroit, as a police officer
And how long have you been employed as a police officer?
for 3 years.
And were you employed as a police officer on April 27th, 2023?
Yes,
Did you in fact work on that date?
yes,
Were you by yourself or with a partner?
I was with a partner,
And what is your partner's name?
Officer Colbro.
And did your duties as a police officer take you to an area at or near John R. and Hillvale Ave?
Yes,
It's then in the city of Detroit, county of Wayne.
yes.
And what brought you to that area?
We were there responding to a shot spotter police run.
And could you explain what shot spotter is?
Shot spotter is a system that detects gunshots.
And on this date, did you receive notice of a gunshot?
Yes, in that area.
And what happened when you responded to this area?
When we made the area, we observed a male walking away from the area.
Did you observe anybody else in the area?
No,
And what did you do when you saw this individual in the area?
we saw the individual. We observed him walking to a Coney Island and then leaving off the Coney Island, and we investigated him. So we immediately walked out of the Coney Island, and once we investigated him, I performed a pat down on him.
And when you say you investigated him, did you approach the individual?
Yes,
And is there anybody present in the courtroom today that you came into contact with on that date?
yes.
Could you please point out that individual and identify an article of clothing they were wearing?
The tan shirt.
Your Honor, let the record reflect the identification of defendants. So reflected. And what happens when you approach the defendants?
Spoke with him. I asked him if he heard a gunshot in the area, and then pat him down just for my safety, so the shots fired in the area.
And what happens when you patted down the defendants?
I felt a weapon-like object on his right hip.
And can you describe what you felt?
Felt like a weapon in a holster.
Was it a hard object, soft object?
Oh, yes, sorry, hard object, yes.
And what did you do upon feeling this object?
I advised my partner that I felt a hard object, like a weapon.
And was the defendant searched at this point?
Yes,
By whom was the defendant searched?
my partner, Officer Colbro.
And was anything recovered?
Yes, a weapon.
And could you describe that weapon?
I do not recall the exact weapon type, but it was a black handgun with a magazine.
Was it a large gun? Was it a small gun?
I'm sorry, yes, it was a large gun.
Do you recall the color?
Black.
And was the weapon placed into evidence?
Yes, it was.
Do you recall the evidence tag number?
No, I do not recall that with the tag number.
Would reviewing your report refresh your recollection?
Yes.
May I approach, Your Honor?
Yes.
And do you recall the evidence tag number?
It was, the tag number was 695428-1.
I have no further questions, Your Honor.
Morning, Officer Reeves.
Morning.
You testified that you were on patrol.
Yeah.
And you were in the police vehicle, right?
Yes.
Were you driving?
No.
You were the passenger seat.
Yes.
Okay, and a shot spotter run came in, what time did that come in?
I do not recall the exact time.
It was around 9:08. Does that sound correct?
Yes, it does.
Okay, and so then you hear that, or you get that notification from the shot spotter, correct?
Yes.
And at what time did you come across Mr. Banks?
At the time, I do not recall.
Okay, would reviewing your report refresh your recollection?
Yes.
Okay. Once you review your report, let me know. So what time did you come across Mr. Banks?
21:17.
So how long was that after the shot spotter run?
Right after the shot spotter, I would say.
10 minutes, 10 minutes, right?
Okay.
Yeah. So 10 minutes after that shot spotter run is when you came across Mr. Banks. Correct? Okay. Yeah, and then so you said that he came out of a Coney Island?
Yes, so when we arrived on scene to there, we observed him walking away and he continued to walk and then walked to a Coney Island. And walked out.
And then walked out, okay. So he was near a business, like a business?
Yes, but we observed him walk towards the place of business and walk into it.
Okay. And you began talking to Mr. Banks while you were still in the car, right?
No, we pulled into the parking lot of the Coney Island and we got out of our vehicles and approached him as he was walking out of the Coney Island.
Okay, you approached him and you began asking questions at that point.
Yes.
And was your body camera footage active then?
No, not in the initial approach.
Why wasn't it active?
It was charging, before charging at that time.
You're familiar with the Detroit Police Department's policy on body camera footage usage, correct?
Yes.
Body worn, okay. You are supposed to have that body worn camera active when you are having civilian encounters, correct?
Yes.
But it was not active,
No, not on approach.
okay. And testified that you patted down Mr. Banks. You didn't see a bulge or anything like that, did you?
No.
Okay, so you approached him and patted him down.
Yes.
Okay. If I can have one moment, Your Honor. And you asked for Mr. Banks' consent to search, to pat him down, right?
Yes.
And he said no.
Yes, he did.
And then and then once he said no, you decided to pat him down anyways.
Yes.
No further questions, Your Honor.
Redirect.
Just briefly, Your Honor, so on what basis did you pat down the defendants?
Excuse me?
On On what basis did you pat down the defendants?
Can you explain more?
What were the reasons for patting down the
Well,
defendants?
him being in the area of the shot spotter and due to my safety, investigating for a shot spotter.
I have nothing further, Your Honor.
Any other witnesses?
No further witnesses, Your Honor.
Next witness.
No, Your Honor.
How are you?
Your Honor, at this time, the people move to find over the defendant on count one, weapons carrying concealed. We heard from Officer Reeves, he and his partner responded to a shot spotter run. They received a call about 10 minutes prior to reaching the area. Upon making the scene of the shot spotter alerts, they observed one individual in the area. So they asked the officer, there were no other individuals that they saw in the area. They observed this individual enter Coney Island and quickly exit the Coney Island, at which point the officers exited their vehicle and made contact with the defendants. Officer Reeves then conducted a pat-down search of the defendants based on shot spotter alert, which alerts the Detroit police of gunshots in a specific area, and for officer safety. Conducting that pat down, the officer felt described as a gun-like object, said it was a hard object in the right waistband of the defendant. His partner then recovered a firearm from the defendant, which the officer testified was a black handgun. People believe they had determined probable cause. Let's find over to the Third Circuit.
Your Honor, we would object to find over here and ask that you dismiss the case based on the fact that this was not a valid search. It's not a valid carry frisk because there was not reasonable, articulable, and particularized suspicion to believe that Mr. Banks, this individual, was armed. Starting with the shot spotter, I won't get into the reliability of shot spotter evidence in general. But this shot spotter run came in 10 minutes prior to the area where Mr. Banks was located. Now, I don't know if the government believes that 10 minutes is a short period of time here, but when we're talking about gunshots, it's common sense suggests that anyone who had fired a gun in an area would take that 10 minutes to get out of that area and would not just be, walking down the sidewalk like nothing occurred. I think that Mr. Banks going into Coney Island is irrelevant. People are allowed to walk down the street, see if businesses are open or closed. They are allowed to walk around like a human being. So that's not reasonable suspicion here. And in terms of the interaction with the officers itself, there's no testimony that shows that Mr. Banks was trying to leave the scene or that he was making any further gestures. There's nothing here that suggests that this person himself was armed or was engaged in criminal activity. The police officers got out of their car and made a brief investigatory stop. Officer safety is irrelevant here. They needed to have something more to suggest that Mr. Banks himself was a person carrying a weapon. And also the fact that Mr. Banks, that they tried to get consent before searching him, also goes to show that they are filling in the blanks from their illegal search. the Fourth Amendment requires that we have that reasonable suspicion. And it's not just a generalized suspicion. What the police officers did here is akin to them asking everyone on the sidewalk for a pat down. And just because Mr. Banks was the only person in the area 10 minutes after a shot spotter run doesn't mean that he doesn't deserve the same Fourth Amendment protections that any other civilian would deserve in this scenario. So for that reason, I object to the bind over and ask that you dismiss.
Your Honor, just briefly, I do believe that the officers did have a reasonable suspicion here to conduct the pat down. There was only a 10-minute difference between when the shot spotter alert came in and when the officers reached the area. They canvassed the area, and there was only one individual who was present in the area where they were alerted to. They then watched this individual quickly enter a Coney Island and exit. And then made the investigative stop. And so we reiterate, people believe in the burden of probable cause and ask them to go over to the third circuit.
Okay. I believe people have been burden of proof, and it is a probable cause standard. There's no set list of elements or facts required to establish reasonable suspicion. What has been presented today is evidence from the officer stating that there was a spot or shot spotter call in the area which he investigated. Question of fact, several things, including the time frame that he arrived to the scene, whether or not the shot spotter notification satisfies or is enough for the articulable facts. But at the probable cause standard, I do believe there's enough to bind over. And once the officer approached the defendant outside of Coney Island, asked if the defendant heard gunshots, and then asked also if the defendant could be patted down. The defendant said no, and the officer then conducted a Terry frisk, was patted down for officer safety. Felt the partner felt the hard object on his right hip, covered a gun, black handgun at the time. So the elements for carrying a concealed weapon have been met. Probable cause standard. I will have you bound over. You are out of custody, Mr. Banks. So it'll be 2 weeks from today, June 13th, will be a arraignment on information date at 9:00 a.m.
Nothing further from the people, Your Honor.
No, Johnson. All right, we're off the record on Mr. Banks. Hardy Davis, good morning. Are you ready on Mr. Harris? Your audio is breaking up a little bit.
I'm sorry. I said yes. I was just trying to get in the hallway.
Oh,
I'm
okay.
sorry. Okay. I'm sorry. I was whispering because they were on the record in there. I'm sorry, Your Honor.
Oh, you're good. You're good. Let's see here. Please get his file. Okay, we're on the record that the people of the state of Michigan versus Christopher Harris, 2356947. Mr. Harris is charged with 1 piece of fleeing vehicle for the cause conference, also with the visual offender for the offense notice appearances.
And this is parking B5828.
Good morning, Your Honor. Aliyah, Kahlilia, Davis, P70729. For Mr. Harris. Mr. Harris is present via Zoom, as am I. And we understand the limitations of Zoom, and we are willing to proceed.
And Mr. Harris, state your name for the record.
Christopher Harris.
Okay. Attorney Davis, do you have discovery on this case?
Yes, Your Honor, I do. And I have spoken with Mr. Harris about the nature and purposes of a preliminary exam, as well as his rights to hold such an exam, and he would like to demand that exam.
I have June 5th, June 6th, no, actually June 5th, June 7th, 8th, or 9th open.
Let me check. One moment. Can we possibly do the 6th? Is that okay? Oh, no, you said the 6th is not open, correct?
That's the only bad day, it's completely jammed.
Okay, then the 7th.
Okay. How about 11 o'clock?
I'm sorry, what time did you say, Your Honor?
11 o'clock?
Yes, thank you.
Okay, so June 7th at 9 o'clock.
Yes,
11 o'clock.
thank you. And Your Honor, Mr. Harris would like for me to ask the court that his file be stamped medical. He's not receiving certain medical and psychiatric care that he should be receiving. He has certain diagnoses, and he's not receiving any sort of care for those diagnoses.
Okay, I will mark his file medical right now.
Thank you very much, Your Honor.
Anything else from either party?
No, Your Honor.
No, Your Honor.
And Mr. Young said I have marked your file as medical, that should be sent over, the information will be sent over to the jail right now.
Thank you, Your Honor.
Have a good one.
All right, you too. We'll see you next week. Bye-bye.
Mr. Harris, your case is over for today. I have marked your file as medical and your exam has been set for June 7th at 11 o'clock a.m. here at 36th District Court.
Thank you, Your Honor. But, you know, they marked this, file medical, some time ago, and I think that the issue is that, they're having, a lot of inconsistencies with obtain, proper, medical staff. And as such, a lot of the individuals who have come into this job to
Mr.
provide,
Harris, Mr. Harris,
they're quitting, they're not staying, if I'm not mistaken, ma'am.
okay, your attorney advocated for you to have your file marked as medical. I'm going to send that information over. I will let your attorney know, and she knows that if something is still not being addressed, she can address the court at any time, okay?
Thank you. Yeah, have a good day, ma'am.
You're all set. Tavion Cheeto, how you say that name?
Cheeto.
Cheeto.
Second H is silent.
Morning, we have a discovery issue that we have to address before we move.
Case 2356900, people of the state of Michigan versus Tavion Cheeto. Charged with one count of assault with dangerous weapon, felonious assault, set for an exam today. Harrison?
Edmonds Milwaukee P 54828, hearing on behalf of the people.
Good morning, Your Honor. Curtis Davenport, P 82678, on behalf of Mr. Tavion Cheatham, who is present in court.
Cheeto, please state your full name, please.
My name is Tavion Taiwan LaRue Cheatham.
Thank you. More. They sent for an exam. I heard that there's some discovery issue.
Yes, Your Honor. I think you were not present on the PCC, but I spoke with Judge Jefferson. There was some outstanding discovery that we were seeking. Green light videos from part of the incident. And there's also, I think, the arrest and part of the incident that take place at the second precinct of the police station. So we're seeking surveillance footage for that. as well as a 911 call, and I think we harvested some body-worn cameras from the arrest. And so I put in a discovery order on that day, but we had not received discovery at this point.
If I may have a minute to find it out.
Sure.
We never, our file shows is that we never received this discovery order.
Do you know who signed the discovery?
I'm not sure. I sent it to you and Judge Jefferson because she was out on that day,
Okay.
but I don't remember if it even came back. But I definitely sent it, and I wanted it to be signed. The day of the PCC.
23rd
Yes.
of May.
Yes, that should be the day I sent it. And Mr. Jefferson or Judge Jefferson had let me know that you,
I don't see it by, you said it to the courtroom email?
Yes. Yes.
I think before I try to find the order, Mr. Sawaki, does that discovery exist?
The officer in charge is here.
Good morning,
Statement.
Council Lord over at Second Precinct.
So you could answer the question probably better. Does that discovery that defense counsel was making, does it exist?
The video of the arrest?
Yes.
Yes, it should be also.
We did receive one body-worn camera, I believe, about the arrest and maybe a dash cam. We're asking for the whole incident, which should be recorded from the second precinct surveillance videos, because it was an arrest that was made right outside the precinct, and it's also across from McDonald's. The report, the police report mentions a green light video, and so that's what we're seeking, is a green light video from McDonald's, and then the arrest, we believe, will be completely shown at the second precinct surveillance videos. That's what we're seeing.
Okay, so as far as the green line video,
There, I have no green light video. I didn't put green light video. I just did the officers body cam video from their vehicle.
okay, and that's why you put in a discovery request.
Yes. It's crucial for the information.
Well, I will sign the discovery order. Are the witnesses here today?
Yeah, I believe I have a witness here today.
Still can't find it.
Would you like me to?
It was sent on the 24th. How likely is it that the green light video was this, or you can retrieve that?
That's very likely, yeah. It's right next to the station, wanting where they were arrested.
So this is actually, I didn't see the request for the discovery order. So this will be my adjournment. Not defense or prosecutor, because I didn't see this assignment for them. Officer in charge, the prosecutor didn't have an order to retrieve that. That was not part of the original discovery. So I guess the question is, how much time do you think you need for the green light to be retrieved?
Just a couple days. just to make sure I can get it, have it updated.
Nathan, your name? That a good day for you, man?
Actually, Judge, can I have it, can I actually talk to my client? Real quick? 'Cause that's gonna be a very hectic time. Judge, can I get a date, actually, um, either, sometime after June 14th? I know that's quite a bit of time.
That's okay. Can you do the 15th?
Yes, I can.
That work for everybody? That day is wide open. What time? Preferably early.
Yeah, what time do you start doing exams?
9.
Oh, 9? We could definitely do, we do 9.
Okay, so June 15th at 9 o'clock. I will have an order for you and right here shortly.
Thank you, Attorney.
Thank you. Prosecutor, you want to sign?
It doesn't matter, it's basically, see if I get a copy. Between hearings.
Attorney Sullivan, good morning.
Your Honor, this is
Okay, we are on the record. People say the Michigan versus Yarul, Melvin, Dale, Carson, Fontaine. Case, I'm sorry, Mark. It's case, I can start over. You can start over. Which case? This is Carson Fontaine.
Okay. All right, I just, thank you.
Okay, I'm sorry. This is the people of state of Michigan versus Jarul, Melvin, Dale, Carson Fontaine, 2356816. Mr. Carson Fontaine is charged one count of malicious destruction of the building, $1,000 or more, but less than $20,000 set for an exam today. Appearances?
Alexander Kirker on behalf of the people, P 86282.
Good morning, Your Honor. Attorney Samar Barrage appearing on behalf of Mr. John Carson Fontaine, who appears in person to the right. Mr. Fontaine, can you please state your name for the record?
Jaru Carson Fontaine.
Anything set for exam, is everyone ready to move forward?
People are not, Your Honor, we do not have all necessary witnesses present.
Anything from defense?
Your Honor, at this moment in time, due to the prosecution's failure to provide producing the complaining witnesses, we ask that this case be moved to dismiss with prejudice.
But it's without prejudice, but not with prejudice, because the people are not ready to move forward. And I am signing it now, it should take one. So what that means, Mr. Carson Fontaine, I'm dismissing it without prejudice. If the people do wish to reissue, they can, but at this time, your case has been dismissed, okay?
All right, thank you so much. Oh, I'm done.
Yeah. You're done.
All right, thank you. So don't leave, just stay right here.
Just walk around with your pictures. All right.
Long way.
Yeah.
Okay. Case 2-56688. Michigan versus Asia Dijon Mobley Street, charged with one count of police officer assault and resisting and obstructing. Set for an exam today. Appearances.
Alexander Kirker on behalf of the people, PD 6282.
Good morning, Your Honor. Attorney Sahar Faraj appearing on behalf of Mrs. Mobley Street, who appears in person to my right. Ms. Mobley Street, may you please state your name for the record.
Asia Mobley High Street. Morning. Okay, the room ready to move forward, this exam.
People are, Your Honor.
Your Honor, at this moment in time, we'd like to make a record of the fact that at the prior PCC, the defense counsel requested. that-
I'm sorry, I can't hear.
At the last PCC, defense counsel made a record of the request for discovery, digital discovery to be sent over. However, today's the day set for examination, and defense counsel is still not in receipt of digital discovery. And the digital discovery in this case exists. According to the police report, page 3, the OIC officer in charge states that they were able to review the body cam footage of both officers that responded to the scene. Yet defense counsel is unable to proceed effectively for cross-examination today of the witnesses without the body cam footage that's referenced in the police report.
Yes, we reached out to the officer in charge after the PCC. I just spoke with him in the hallway and he said he has uploaded it several times. I'm checking now on evidence.com and I'm not seeing it.
You need some more time to check, or
I may need to confer with the officer in charge just to see what he uploaded it under. To make sure.
You have to see it.
they were gonna go off the record. Say check in. Taser. Okay, back on the record on this Mobley Street. Mr. Kirker, you need to speak to your officer in charge.
Yeah, so I was able to speak with the officer in charge, confirm that it was the police report number that he uploaded to the body worn camera to evidence.com. He confirmed that yes, that was the correct number, however, it's still not appearing. He said that it's just body worn camera from this incident that he could re-upload it.
Re-upload, yes, go to the precinct to do that.
I believe so.
Is it more than just body cam or is there something else?
It's the body cam, only the body cam. And Your Honor, if I may inquire if we're, what officers checked in today for the examination?
I would.
That would be also charged and then also Solomon.
Your Honor, the complaining witness listed on the, or the officer that is said to have been assaulted is James Burrows. I'm sorry, I apologize. According to the police report, the complaining witness that's listed is, James Burrows, who has not appeared today. Salazar, I'm sorry if I'm pronouncing it incorrectly. It's just an officer who was there that was stated to have witnessed according to the police report. So we ask that regardless of the discovery issues that this case be dismissed due to the failure of the complaining witness to show up.
I spoke with Officer Salazar to make sure that he had seen the incident, and I believe that we could proceed at this standard with just Officer Salazar's testimony.
That would be up to the people if they think they have enough to move forward. So back to discovery. Can you bring the officer in charge?
Sure.
Your Honor, may I? Before the officer
Sure.
comes in? It's just that the facts of the case are that the officers had responded to a call for malicious destruction of property, which the complainant or victim refused to press charges, and it was after a review of the body cam that these charges were brought against my client.
Sir, can you state your name for the record?
Officer Edward Pulaski. Oh, wait.
Trying to figure out, so it's just one body cam that has not been tendered to defense counsel that you have, that you can upload? Is that
I
correct?
uploaded it on time, Your Honor. I don't know if it's an issue just evidence.com right now. It's not showing up on there. It's up to 2 emails since this case started. We upload it each time. I can go back to the base and do it again.
So you uploaded it. So
Yeah, I do have it still sitting on my desktop. So I can do it a couple times now.
I don't know what the technological issue is. Mr. Kirk, you don't have it either?
No, I'm checking right now, and it looks like,
So, Attorney Raj, what you just mentioned regarding the video and the charges, I think that's something that have to be discovered or brought out during exam if it would be held. Of course, you can make argument, because I don't have anything to work with.
Yeah.
I do think this is good cause for an adjournment for the simple fact that OIC has uploaded, and it's just not being sent or properly uploaded. I want to set this for PCC, make sure that the discovery is uploaded and you receive it, Attorney Raj, before we set this for another exam with no video.
That makes sense. Thank you.
You will come back on Friday, or will you be here? It won't matter, sorry.
yeah, I should be here on Friday.
Okay, let's come back on Friday to see.
I can upload it.
For PCC, correct?
PCC, yeah.
I can provide you with my cell phone today. Once I upload it. Next week, see it.
By Friday, everything should be good.
I hope so.
Hopefully.
It's been like a month and a half.
And if not, would you be able to just upload it on a USB?
Yeah, I can do that.
So Ms. Mobley Street, have you been listening to what's going on?
Yes.
Okay, so Friday, we're going to adjourn your case to a probable cause conference so that we don't have to have subpoenas sent out for witnesses in the event that there's still some issue with this video that for some reason can't be uploaded. So you don't have to come Friday if you don't want to, but of course, this is your case. You can log on Zoom 8:30 and just listen in to see whether that serves. Okay? So you don't have to come in person on Friday.
Okay.
All right. So let's do the second at 8:30.
We're for the defense.
Okay. Anything else?
Nothing for the defense. Thank you, Your Honor. Have a good day.
Council, still issue.
Some issues with evidence.com. I've had another case where the officer has loaded them up and you can't find it. So I've got IT working on that. So
Okay.
maybe you can find it. It's a general problem. You find it, fix it.
Evidence.com.
Evidence.com.
Specialize in evidence.
Yes, Your Honor, I know it purges everything after a certain amount of time. I don't know if they're purging it too quick or they're just seeing older cases that are a few months older, just purging everything. I don't know what's going on. But I've had multiple issues with other cases and then just say, like, we'll wait for a little bit. And then
Come back. That's weird.
Have a good day.
Like evidence.com is doing that?
yes, I don't think it's 180 days or 280 days, it purges automatically, but it just seems like some cases that purge too quick. That's why I keep it on my desktop, just in case. Thank you, Your Honor. Yes, sir.
case 3055862. People of the state of Michigan versus the White, DWIGHT, Richard Dobbins, DOBBINS, charged with one kind of weapons carrying concealed, set for a walk-in rape appearance.
Alexander Kirker on behalf of the vehicle P 86282.
Judge, may I please this most time for Betsy J. to sign 58609 on behalf of Mr. Dobbins, who is present in the court tonight.
Dobbins, can you take your full name for the record, please?
Right, Dobbins.
Good morning.
Good morning.
Okay, I see probable cause conference was scheduled for May 8th. That's the last court date.
That was, Your Honor. Unfortunately, I was in DC beginning of May, and unfortunately, I came for training on federal capital matters. I came back and had COVID. So I know that unfortunately, I was not available or was under the weather for that next 10 days. I did contact Mr. Dobbins. Mr. Dobbins did contact me after that. And unfortunately, last weekend I was in Atlanta. I can't say unfortunately. Fortunately, I was in Atlanta
Right.
last weekend for my son's graduation from Morehouse.
Right.
Thank you. So we're requesting, walked in today, requesting that the warrant be set aside, get a new date for the, I think we have a PCC and I know we're going to do an examination on this case.
Okay, I'll set aside the warrant. The bond was set at 1,000 personal. I'll keep it at 1,000 personal.
Thank you, Your Honor.
Let's see, do you have discovery?
I do.
This is June 8th.
June 9th does work. And I think I'm back before you on June 9th on the PCC. Could we do it on the same day?
On here.
I think we did Mr. Dale Williams.
Okay. 9:30.
9:30 is fine, Judge. I appreciate it.
June 9th at 9:30. Mr. Dobbins, that's in person here, right back in this courtroom, where you're standing right now, June 9th, okay? At 9:30.
All right.
Anything else?
That's it.
Right. Have a good rest of your week.
You as well, Judge. Thank you again. Thank you. Thank you.
Okay. You need a minute or?
I'm ready, Judge.
Only case 235-5839, the people of the state of Michigan versus Armand Wilson. Wilson is charged count 1, weapons carrying concealed, count 2, police officer assaulting, resisting, and obstructing, count 3, weapons on the firearm. Set for exam today. Appearances.
Edwin Sawaki, P5488, appearing on behalf of people.
And good afternoon, Judge. Neighborhood Defender Service by Jackie Folkowitz, P81653, on behalf of Armand Wilson, who stands to my right. Armand, will you state your name for the judge, please?
Armand Wilson.
Good afternoon. Okay, is everyone ready to proceed?
People are ready to proceed, Your Honor.
We're ready, Judge.
Okay, there's anyone on YouTube or on Zoom who may be a witness on this case, now's your time to log off. Same if there's anyone in the courtroom who may be a witness or testify, now is your time to exit the courtroom. Mr. Milwaukee, call your first.
Oh, Officer Trevor Dorsey, please.
First name, please.
Make sure you speak up in the microphone.
Thank you. Officer, could you state your name for the record, please?
Yeah, Trevor Dorsey,
And what's your occupation?
Detroit police officer,
How long have you been with that agency?
3.5 years.
And were you on duty May 9th, 2023?
Yes,
And were you in the area of Building and West 7 Mile Road, City of Detroit, County of Wayne?
yes.
What type of uniform were you wearing?
I was in my special operations uniform, green hands, flex up.
Pretty much what you're dressed like now?
Yes,
And what were you doing in that area?
I was in the area chasing for a Abram suspect, assault with intent to murder suspect.
And what occurred in that area?
Did you say chasing or looking?
I was looking for a Abram suspect. In the area. You said what happened there?
Yeah, what were, when you arrived?
When we arrived on, was it Fielding?
Building in West 7 Mile.
Yeah, when we arrived, we saw him walking north on Fielding, on 7 Mile,
I'm sorry, saw who?
the suspect.
And is that person in the courtroom today?
Yes,
And could you point out his location, describe the piece of clothing that he may be wearing?
yeah, he's wearing a black and white jersey, shoes, black jeans, black hoodie.
Let the record reflect, excuse me, Your Honor, reflect that the officer has identified the defendant.
Or reflected?
What did you observe about the defendant?
When we arrived and we took the first suspect into custody, he ran from us with a gun in his pocket.
How do you know there was a gun in his pocket?
I saw the gun in his pocket.
What happened next?
He gave chase between the houses and we took him into custody behind 19336 Pearson.
And did you observe anything?
Yes,
What was that?
I observed him throw the gun into the backyard of 19330 Pearson.
Was that weapon recovered?
Yes,
What was done with that? You didn't, let me rephrase it. You didn't recover it yourself, did you?
no,
Who recovered it?
my partner, Officer Reed.
And you know what happened to that weapon after it was taken into custody?
It should have been placed on evidence.
Objection, lack of personal knowledge and speculation.
He said what he should have been doing. He didn't say it was.
So speculation as to, I would ask that his answer
I'll
is trivia.
rephrase the question if not come out correctly.
But he still didn't say what should be done. But
was not that.
Understood.
Right, what happened to the weapon, if you know, after it was recovered?
Okay, my partner takes some evidence at the 11th precinct.
I have nothing further for this witness, Your Honor.
Officer Dorsey, you just testified that your partner placed the weapon on evidence.
Yes.
You didn't observe him place the weapon on evidence.
I'm sorry?
You didn't watch him place the weapon onto evidence.
No,
Okay, so you just heard, he shared with you that he did that.
no, that's the policy. He puts it on evidence. That's the policy of our precinct.
Okay. You personally you didn't place it, that's clear, correct?
Right.
And you didn't watch your partner place it.
Right.
So you're assuming that he placed it based on the policy.
I'm sorry?
You're taking an educated guess that he placed it because that is what he is supposed to do in accordance with DPD policy.
You can say that, but yeah.
You mentioned that, I think you pulled up, it was on Fielding Street,
Right.
and you're in a squad car.
Right.
You are in the rear passenger seat, correct?
Right. Yes, ma'am.
And there are two other officers in the squad car.
That's correct.
Okay, one obviously is driving the vehicle, the other is in the front passenger seat.
Right.
You testified that you were looking for an AWIM suspect, right?
That's correct.
And the AWIM suspect you were looking for had braids.
I don't recall what he got here.
You were looking for Elijah Robinson originally.
I do not recall his name. I don't know his name.
You testified that this gentleman right here is the person who you were investigating for an AWIM.
I testified that he took off with the gun in his pocket.
You didn't know that he was the suspect in an AWIM investigation until after you arrested him.
That's correct.
So after receiving information either from your superior or one of your partners, then you confirmed that he in fact was a suspect in an AWIM investigation.
Right after he's in custody, right?
After he was in custody. Okay. When you pulled up on Fielding Street, as you said before, you were in the back rear passenger seat, correct?
Right.
And there were actually 3 people, including this gentleman, walking on Fielding.
Yes, that's correct.
And they were walking on the side of the street closer to the driver's side of the vehicle.
That's correct.
They were not walking on your side of the vehicle.
I was the driver.
You just testified you were behind the passenger.
I said, I was on the rear seat.
Okay. So you were behind
The driver.
the driver. Your Honor, may I approach? Sure. Officer Dorsey, I'm gonna play like 15 seconds of dash camera footage and then I'll stop it and ask some follow-up questions if that's okay. Okay, I'm starting for the record at 45 seconds. I'm stopping for the record at 1 minute and 1 second. Officer Dorsey, do you recognize that?
Yes.
What is it?
I'm sorry, can I see it one time?
Oh, sure. I guess what is the recording of? If you know, or I can play it one more time if that's helpful.
Yeah, can I see it again?
Yes, absolutely. Okay, do you recognize this recording?
Yes.
Okay, and what is it?
That was the day we took, that was recorded from the case, yes,
Okay, the incident that you're testifying about today.
yes.
And it's a clear and accurate depiction. It hasn't been modified in any way.
Right.
Your Honor, I would move for the admission of the dash camera footage at this time.
Okay, it'll be, any objection?
No objection.
It'll be admitted.
So Officer Dorsey, you testified that there were 3 individuals walking, correct?
Right.
And at least one of those was an AWIM suspect.
Correct.
And the other gentleman, the gentleman seated here, you later learned was an AWIM suspect.
Correct.
And the gentleman seated here took off running.
Correct.
And he took off running when the cops, you and your team, pulled up on him.
After we took the suspect into custody, he took off with the gun in his pocket, yes.
And your testimony is that you saw a gun in his pocket.
Yes.
So if it's in his pocket, how could you see it?
I'm sorry, it was taken out of his pocket.
Oh.
And when he ran, he grabbed the gun to hold it, so it don't fall out of his pocket.
Okay, so it was visible. It was outside his
Yes,
pocket.
I saw his gun in his pocket, yes.
Okay, you had no trouble observing that it was a firearm.
I'm sorry?
You had no trouble seeing that it was a gun.
Right, no trouble, I saw the gun, yes.
Right, so it was clear as day that that's a
It
gun.
was clear as a gun, yes.
Just one moment, Judge. I have no further questions, Judge. Redirect.
Officer, when the,
I'm sorry.
when the, defendant ran away, you were all out of the car, correct?
Yes.
I have nothing further.
Nothing further, Judge.
Any other witnesses?
Yes, I'm sorry.
No,
Yes,
go ahead.
you call Officer Tyke Reed. Officer, for the record, could you state your name and occupation, please?
Officer Reed, police officer.
And how, you're a police officer with the Detroit Police Department?
Yes, sir.
And how long have you been with that agency?
4 years.
And were you on duty May 9th of this year?
Yes.
And were you in the area of, on duty in the area of Fielding, West 7 Mile Road, City of Detroit, County of Wayne?
Yes.
And, how were you dressed on that day?
Vest, green and black, white, green and black.
And why were you in that area?
I'm over there, assisting our surveillance team with taking down the suspect.
And, what was, just for clarity, what was the, he a suspect for?
He was wanted for assault temporary.
Okay, and while you were working there, did you observe anything else?
Yes, once we took down suspect wanted for assault with intent to murder, I observed the male begin to run, holding his front right pocket as if he was trying to conceal a weapon or contraband.
Is that person in the courtroom today?
Yes, sir.
Did you point out his location and identify a piece of clothing that he may be wearing?
As he said right there with the afro and the black hoodie.
Let the record reflect that the officer has identified the defendant.
So reflective.
After the defendant started running away, what happened?
My partner, P.O. Dorsey, and I began to chase the offender on foot. And after a short pursuit, my partner, P.O. Dorsey, detained him in the rear of 19336. I have to refer to my report to the actual street.
You have a reason?
Yeah.
Please do so.
Yes, 19336 Pearson.
Okay. Were you finally able to apprehend the defendant?
Yes, my partner, P.O. Dorsey, detained him.
Okay. And was a weapon found?
Yes, my partner, P.O. Dorsey, advised me.
Objection, hearsay.
Yes, accepted.
Yeah, under people versus. I believe it's Dixon. Information between two police officers who are working is not hearsay.
Can I see the case? I've never heard. I don't know under what rule of hearsay is that.
That's a Supreme Court decision.
Michigan Supreme Court.
Harlem Yard,
Supreme Court.
Michigan.
I read the whole thing and I can read it aloud here. Or,
Go right ahead.
yeah, this is a 1974 opinion. I don't know what rule of evidence they're citing. We hold that in deciding whether to arrest for the misdemeanor of driving without an operator's license, a police officer may properly rely on information obtained by radio from another officer who is examining an official record. That such information becomes part of the arresting officer's knowledge, which he can consider in deciding whether a law violation has occurred in his presence. That is not the case here. We're not talking about a dispatch. If we were, which I didn't object to concerning the AWIM information, which is not something that these officers were privy to. But for instance, for that type of information over a dispatch, I did not object. Information between two officers who are talking on the scene, where one officer is perfectly capable and just did come in here and testify before this court, I do not believe there is a hearsay exception that allows for that to come in, nor have I heard the people cite the rule of evidence that they're relying on.
It also says, courts and other jurisdictions have developed a police team qualification on the present requirement of many officers who are working together on a case to combine their collective perceptions so that it is, if the composite otherwise satisfies the presence requirement, that requirement is deemed satisfied, although the arresting officer does not himself witness all the elements of the offense.
Is it sense of impression? Is that the exception?
This isn't hearsay. We're talking about in here, what I interpret is we're talking about whether there's probable cause to arrest. Yes, there is an exception that allows for officers to combine information to establish probable cause. There's not set in. Furthermore, what he just cited is saying that in other jurisdictions, it's not even saying.
I don't even think it matters here in this case.
I don't think it's.
But I would like to see that case really done. The testimony was that the officer stated that your partner advised you that the defendant had a gun on him.
No, my partner advised me that he observed the offender toss the gun into the rear of the location.
Okay. So if there's not an exception that you can name, then I can't even make a decision. It has to be hearsay unless there's an exception, a hearsay exception. not just case law.
I would also argue that we're not offering it for the truth of the matter, whether the defendant had a gun or not. We're offering it, in fact, it's already on the record that he tossed the gun.
That's why I don't understand why it matters. Because we already heard testimony that he talked.
Okay, I'll move on then. Officer, did you recover the gun?
Yes,
What type of gun was it?
it was a black Taurus 9mm.
Was it loaded?
Yes,
What happened to the weapon after you recovered?
after I recovered and I made it safe and put it on vehicle.
And eventually, did you enter into evidence?
Yes,
I have no further questions.
Officer Reed, when you arrived on scene, you were looking for an AWIM suspect,
yes,
and that suspect was a black male with braids or dreads, correct?
yes,
And he was in gray jogging pants?
yes,
And that person's name, the suspect, is Elijah Robinson.
yes,
This is not Elijah Robinson.
correct,
Correct, as in this is not Elijah Robinson.
correct.
So to be clear, you were not looking for this gentleman right here when you arrived on scene.
No,
You did not have an arrest warrant. Because you lived there right when you arrived on scene. I have no further questions.
No, Your Honor. Yes, Officer Linda Cook, COOK.
Raise your hand. Swear to tell the truth, no one to remember, but. Yes, Your Honor. Okay. Whenever you're ready, Mr. Lucky.
Excuse me, officer, could you please state your name and occupation for the record, please?
Melinda Cook, I'm a Detroit police officer at the 12th precinct.
How long have you been in that, police officer?
Approximately 5 years.
And what's your relationship in, this case?
The officer in charge.
And did you happen to have an opportunity to take a, statement from the defendant?
Yes, sir.
Was that on May 10th of this year?
Yes, sir.
And did you, read him his rights?
Yes, sir.
And how was that done?
We did, an interrogation, I presented him his rights, asked him what was his highest level of education. I also allowed the defendant to read the rights, and I asked him, did he understand his rights? The defendant said yes, and he signed his rights.
Okay, and did he make it, in fact, make a statement?
Yes, sir.
And what was that statement?
That statement, he told me that he was in the area while walking down the street in Detroit, Michigan, and he saw a black SUV pull up. The officers got up, got out. He said he got the fuck on. He said he tossed a weapon. He mentioned an officer that had waves for the taser. And then he said another officer hit him with a truck, and then he was kicked in the ribs. He also stated, I asked him, was the gun that was it his? He said yes, and that he purchased it from Action Impact, but it was not registered.
I have nothing further, Your Honor.
Officer Cook, did you record this interrogation?
Yes.
So that will be, that if it hasn't already been made available, will be.
This should be on evidence.com.
Okay. Officer Cook, Mr. Wilson was intoxicated at the time that you took the statement, correct?
I'm not for sure. He did tell us that the night before he had been drinking, but I don't know what his intoxication level was at that time.
And you prepared the like Detroit police request for a warrant in this case, correct? And the officer in charge?
The arrest warrant for this CCW?
Strike that. You, as the officer in charge, you prepared like the details of investigation.
Yes, ma'am.
And in the details of investigation, you indicated that my client had been drinking alcohol before he was arrested.
The night before, yeah.
And you questioned him, well, at the time, if you recall, around what time?
It would have been late afternoon on the 10th.
Okay, and he was arrested, you're saying, on the 9th?
I believe so. I don't.
Or was he arrested on the 10th?
I would have to look at my report. I can't recall. It would have been the 9th or the 10th. We have a 48 hours to submit the warrant.
Okay, it was within that 48-hour period that you
Yes.
questioned. You didn't ask him how many drinks he had had?
No.
And you didn't ask him whether he was under the influence of any other substances?
No.
So he just indicated to you that he had been drinking and you left it at that?
I don't recall exactly that.
I have no further questions. Can you redirect?
Officer, based on your experience as a police officer, at the time of your conversation with the defendant, did he show any indications of being under the influence?
No.
Nothing further. No, not today, Your Honor.
No witnesses, Judge.
Okay. People moved for a bind over against the defendant on count 1, weapons carrying concealed, count 2, police officer assault and resist and obstructing, and count 3, weapons felony firearm reserve argument.
Your Honor, the defense objects to the bind over on all counts. I'll start with the CCW charge. As the court is aware, concealment is an essential element of the crime of carrying a concealed weapon. People versus Reynolds, 38, Mishap, 159, 1972. A weapon is concealed when, quote, it is not discernible by the ordinary observation of persons coming in contact, with the person carrying it, casually observing him, as people do in the ordinary and usual association of life. As people versus. Oh, yes, of course, apologies. People versus Kincaid, 61, Mish App 498, 1975. The jury instruction for concealment, which is Michigan Model Jury Instruction 11.1, provides the pistol is concealed if it cannot easily be seen by those who come into ordinary contact with the defendant. Your Honor, this officer testified that he saw it was a pistol clear as day. So I don't understand how the people can meet their burden of establishing that the pistol was concealed on his person. The best possible argument people could make is based on the officer's testimony that he saw the pistol in his pocket. But then on cross, he testified that the pistol was out of his pocket and you could clearly see that it was a pistol. I do not believe this is a question of fact. He testified that it was easily discernible. So there's no other wiggle room with regard to the issue of concealment. That can move me to my next argument concerning the resisting arrest. Your Honor, a person has the right to resist an unlawful arrest. In this case, the basis or the alleged basis for the arrest was the crime of CCW, carrying a concealed weapon. However, people don't have probable cause on the issue of concealment. Therefore, my client was not required to submit to an unlawful arrest of his person. That's People versus Moreno, M-O-R-E-N-O. It's a Michigan Supreme Court 2012 case where the people bear the burden of showing that the command and or basis for the arrest was lawful. They have not done so in this case. The felony firearm would be attached to that, and as such, Judge, I do not believe the people have met their burden, and I would ask this court to dismiss the case.
Your Honor, the officer testified that they saw the gun in the pocket, and that they saw that it was a pistol in the pocket. That obviously the defendant was trying to conceal it, whether he did so in such a manner that couldn't get caught is question, obviously questionable, and it's quite frankly a question of fact, whether or not those officers saw what they testified they saw. There's not, this is a probable cause hearing, there's enough evidence to show that they had, they saw the pistol. The defendant took off running and ended up hiding out in a backyard, trying to escape to a backyard, tossing the gun. The gun was recovered on interrogation. The defendant admits it was his gun and he had it. So there's more than enough probable cause to find us over there, sir. Thank you.
I do think it's a question of fact regarding count one. The elements state, one, that the defendant knowingly carried in this case, a gun. It does not matter why the defendant was carrying the weapon, but to be guilty of this crime, the defendant must have known it was a weapon. I believe that is satisfied. Second, that the gun was concealed. Complete invisibility is not required. A weapon is concealed if it cannot easily be seen, as you stated, by those who come into ordinary contact with the defendant. That would be a question of fact, prior fact. Testimony from Officer Dorsey is that he saw the defendant with a gun sticking out of his pocket, and then saw the defendant run and toss that gun while running. And second officer, Officer Reed, that he recovered that gun in place of evidence. So I believe that count has been satisfied. For count two, for a police officer assaulting, resisting, and obstructing, people have to show the probable cause standard. First, that the defendant assaulted, battered, wounded, resisted, obstructed, opposed, or endangered the police officer. In this case, it would be Officer Dorsey and Officer Reed, who were performing their duties. Two, that the defendant or had reason to know that both officers were at the time performing their duties. We have testimony that they were dressed as they were dressed today in green pants and black top police vest. Third, that the officers gave the defendant a lawful command, was making a lawful arrest, or was otherwise performing a lawful act. That would be the question of fact regarding whether or not this was a lawful arrest, according to defense counsel. I believe it's been satisfied at this court. And fourth, the defendant's actions were intended by the defendant, that is not accidental. I do believe that the acts were intentional by the defendant. So with that, I do believe that the people have met burden of proof with the, of course, count 3 felony firearm that is attached to the resisting and obstructing count. Mr. Wilson will be bound over to Third Circuit Court for an arraignment on the information. Your date will be 2 weeks from today. It's going to be June 13th at 9:05 p.m. at Bond. Anything else for the party?
No, Your Honor.
Judge, just, I don't believe I have a copy of the interrogation video, at least in my evidence.com file. If you could just reshare that.
Okay.
I'm sure I'll address it at circuit court as well, so if you'll just make a note. Thank you.
You wait outside.
Mr. Milwaukee, did you, I still don't have any motions from, for the 130. I just have a link to the treatment.
Coming back. Have a good day.
You actually have motions.
Yeah. I thought I sent that over to you.